Peace of mind means that you don't think about this situation all the time. We've all had problems on jobs. My first job, I had a very difficult supervisor that fired everybody and except me. I set the record, so I know how stressful it is. So I think peace of mind is a great thing when you can get some closure and put something behind you.
Welcome to the Verdict Signal podcast, where we feature how top attorneys help people make informed choices, avoid common mistakes, and move forward with confidence. Now, enjoy the show, and here's your host.
Daniel Gao here. I'm the host of Verdict Signal, and today we're expanding our conversations to the experts who protect what people build, their careers, families, and businesses. I have Gary Costales, who's been practicing employment law for more than 30 years, representing both deserving plaintiffs as well as management throughout the state of Florida and occasionally outside the state of Florida. He is board certified in labor and employment law and still enjoys helping people throughout their legal issues. So Gary, welcome and glad to have you here.
Thank you. Good to be here.
Yeah, so let's start from the very top, Gary. How did you first get interested in the legal field?
I think that's a good question because I think it's relevant to clients. My own personal story is well, first off, I wanted to do something creative. And I worked in advertising for a while. I had a lot of different jobs before college, and then I took a constitutional law class. I liked it. I got into employment law and civil rights. We're all influenced by our families, and my father was one of the first Hispanic police officers in New York City. He was a little darker than me, so he encountered a lot of discrimination. But he started various organizations in New York that are still around today. So civil rights was always a topic around our house. We didn't really talk sports. He talked a lot about civil rights and the news and things of that nature. So I think that was an influence, and I wanted to do something that's going to help people. And I think law does allow you to be, somewhat creative. You have to be creative in how you package cases and things of that nature. So that's sort of a thumbnail of how and I like law. I took a constitutional law class, but I really wanted to do civil rights. I worked for the EEOC early in my career. Early in my career too, I also figured out that you have to get the whole story because not everybody, some people are terminated for legitimate reasons. My father was also a manager, so I got that perspective as well. So I got a little bit of both, the management perspective and also a desire to, fight for right, which is a platitude people use, but, help people out.
Okay. And I think you kind of alluded to this as far as like getting the entire story, but what's one thing you really wish more people understood about working with a lawyer?
I'm not sure how to answer that because there's such a variety of approaches that people have. I think people have to understand that the relationship is like a partnership. I do better when people partner with me. And I think one of the most important things is to manage expectations. To go into this, to go into an employment case knowing on the plaintiff side that you're always not going to get the result that you want to begin with. You have to get the result that fits your situation, given the facts, the law, and really, in my area of law, how people are going to testify. So it's hard for me to say what people should be doing differently because I think as I get all kinds of approaches. I get people that are great partners from the beginning. I get people that may not be, but the key to the whole thing is really allowing my client to understand the process so that we can get the best result.
Okay. And I guess to kind of clear up this part, because I think some people have some misconceptions when they work with a lawyer, is that they may be coming in and be like, well, I don't want to give you the whole story because maybe there's something I did that probably maybe wasn't the right thing, or maybe it's going to hurt my case. So if I don't tell you and it doesn't come up, I'm going to be in a stronger position. So in a case like that, is it better for them to kind of share everything with you? Because like you're more the representative, you're not like the enforcer of the law, like getting them in trouble, right?
100%. That goes through both sides. I want to know whether, and I represent management as well, whether it's plaintiffs or defense, I need to know the whole story. I need to know the whole story, warts and all, so that we can deal with that. No case is perfect. When somebody goes into a deposition, you're not going to take a perfect deposition. There's always wrinkles that come up. I think that that might answer your question.
Mhm. Yeah, it definitely does. And now when it comes to like the most common situations where your clients come to you, like I know with employment law, especially when you are presenting both sides, there's a lot that goes into it. Unlawful termination, discrimination, like all these different things. But what would you say is some of
Mhm.
the most common situations that your clients come to you for?
On the plaintiff side, it's somebody that's been fired.
Mm.
On the defense side, it's there's a lot of overtime cases here in South Florida. We have more overtime cases than anywhere else in the United States for various reasons.
Mhm.
But the most common issues are discrimination. I do a lot of sexual harassment cases, and I also do quite a bit of non-compete work. A small area of my practice, but one that is growing, are the key Tom actions, which is a False Claims Act, and that's where uh, uh, the government has been defrauded, and if there's a lawsuit filed that's filed privately under seal, the person that alerts the government to the fraud is entitled to 25% of whatever the fine or penalty is. I do that as well.
Oh,
But
wow.
I think the majority of the cases that I do are discrimination cases, which are often can get complicated very quickly.
Okay. And when it comes to these discrimination cases, what would you say is some of the most common misconceptions people have about this? Like maybe whether it's on the employer side or even the employee side. Like, as I mean, as I've talked to
Mhm.
lawyers all over the country, is like they kind of bring up certain things. I'm like, oh, I never knew that. So, like, what are some of those common misconceptions where you kind of mention this to people like, oh, I didn't know that?
The biggest misconception, I think, is that people think that they're entitled to fairness in their job.
Hmm.
And we're an at-will state. Pretty much, I believe every state is an at-will state, which means that you could be fired for any reason at all, good reason, bad reason, no reason. You can leave for any reason at all.
Hmm.
So a lot of people have a misconception that if I'm treated unfairly, that equals a case.
Hmm.
And that's not always the case.
Hmm.
Another misconception is that, and it's not really a misconception, but it's hard for people to see the big picture, whether you're on plaintiffs or defense. It's hard, a lot of people think that if they tell their story in court, that's it. They're going to win. They're going to prevail. Everything's going to go their way. And it's hard for them to take into account what the other side's going to say, how witnesses are going to come across, and that goes across the spectrum. Um, and it's human nature. People believe in the power of their own testimony. Now, that's not to say that you can't prove a case just based on your own testimony. You absolutely can, but it's very hard for somebody in that position to really appreciate how the other side's claims or defenses are going to resonate with a jury. All this is geared towards going to trial. Employment law is geared toward going to trial. Most cases don't get to trial because they settle, the majority of the time, but it's all geared towards going to trial. So when I first take a case, I take it with an eye towards, this is going to go to trial. We need to prepare it accordingly. And as you go along, I think people find out, oh, well, this is what this person's going to say. We take depositions and they find out that, well, there's a twist now that I didn't anticipate. And that's just, a lot of times that's often inevitable. That goes both ways. You could be surprised in a bad way
Hmm.
that something doesn't go your way, and you could be surprised in a good way as well, that things go, better than you expected.
Okay. And when it comes to the mistakes people make, like would you say is some of the biggest mistakes people make before they call a lawyer?
I think it depends on the situation. I think that when it comes to discrimination claims, because that's a big area of employment law,
Mm.
they they may make a complaint verbally. And I'm always telling people, you need to put that in writing to ensure that your rights are intact, that it's clear that you've complained about unlawful discrimination.
Mhm.
I think that's a big mistake. Again, you could prove your case by saying, well, I verbally told this person that or I complained about it, but it's always good to put it in writing for various reasons, obvious reasons, really. And a not so obvious reason is that there are times when an employer might say, well, we didn't know about this complaint, when in fact they did. So that could be a common defense in retaliation cases.
Mm.
Um, yeah, those are some of the highlights, I think.
Okay. So as far as I guess some smart steps that they can take, so notating everything, making sure everything's in writing. Is there anything else that you kind of recommend as far as like some of these smart steps that they can start taking in this process?
Well, I think that a little bit of knowledge of the law is always a good thing. Now with the internet's always a good resource, but now with the benefit of AI,
Mhm.
they can get decent answers. I mean, AI still hallucinates now and then, and it wants to please, but it can be a good resource if you really recognize how to use AI and that it points you to objective sources. It can give you some information about what it takes to prove a case. I think any case starts with a suspicion of something going wrong. And again, discrimination is one of the big areas that I practice in. It's one of the big areas of employment law. And I don't, if a client tells me, well, I don't know why they fired me or it could be this, I'm a little bit lukewarm on that. This is a very difficult area of law. So I think it starts with a suspicion that I've been treated wrongly, terminated most often because of an unlawful reason. And I think that once you have that suspicion, you should have some idea as to how to prove your case. A lot of times it comes up organically.
Mhm.
If it's a race case, the person notices that the white employees are treated more favorably. Whatever it is, age, race, sex, color, religion, national origin, disability, sexual orientation. So I think that that's something. In addition, it sometimes is, we're all sometimes we all have a problem seeing the forest through the trees. And if somebody has the ability to think of things objectively, think like an owner, that could be, helpful as well. How is this, going to, look to somebody else and what is, why is it that this action is being taken, to really look at the big picture. Yeah.
Okay. And so since you represent both sides, the employer and the employee, is there really kind of a big difference from their side, like when they're doing their preparation, when they're kind of getting ready, when they're working with a lawyer? Is really any difference between these two sides, or is it generally kind of the same idea? Like you're doing the preparation, you want to make sure everything's written down, you want to share everything with your lawyer.
Hmm.
Like, is it largely the same, or are there some kind of unique differences between one and another from their end?
Well, the commonalities are the discovery process. The discovery process is the beginning of a case. It really starts at the initial client meeting, and I think the commonalities are gathering, all the evidence that you have and preserving evidence as well. That's a big commonality. As far as differences go, I think there's more commonalities than differences in how to litigate a case. Since this is all towards, it all goes towards preparing a case. Um, Gathering information is one of the, and preserving information are, the commonalities there.
Mhm. Okay. So pretty much the preparation is going to be largely the same. Is there any kind of major differences, or is it really going to be more the differences are in the individual cases than the situations themselves?
I think the differences are in the individual cases. Every company is different, and I I'm trying to think about that a little bit more because I haven't really thought about that. What are the differences? I mean, in the beginning of every case, I'm gathering information. Um, it also entails talking to witnesses as well. I think that's a commonality as well.
Mhm.
I don't know that I could really draw any huge differences.
Okay.
Um, I think that again, every client is different. Every client approaches things differently, and you have clients that are more on the type of person or company that keeps copious records, and you have some that are not so good at that.
Mhm.
Time is always a factor. I think that when somebody's in a lawsuit, a lot of times they don't have the time to think of things,
Mhm.
or to really to devote. They're always looking for time to uh, you know resources to put into the case. Sometimes it's easier for a company, but I just one thing about this area of law is that I'm dealing with all kinds of different people and companies. I mean, I have blue collar people, then I have high end executives. I've had small, tiny companies that are convenience stores that I've defended. I had a representing Cracker Barrel in a couple of cases. So my practice is kind of unique in that I'm sort of all over the place. So I've had to adapt to uh, working with you know clients that have different personalities. And when I say personalities, I mean, I'm talking about a company too. A company has a personality as well. And I just deal with a whole variety of scenarios. It's any given day, I may be talking to somebody who, makes close to minimum wage, or advising an executive that makes, close to $1 million a year.
Mhm.
So there's a big variety there.
Okay. Now, I want to go back to something you said originally as far as like the at will part of employment. So in my mind, it almost seems like there's a contradiction there. It's like, well, most states, if not all, are at will. They can kind of like fire you for any reason, but then you can't fire people for certain things like discrimination and
Yeah.
sexual harassment and all that. So like, I guess where
Mhm.
is that divide between you can kind of fire people for whatever reason versus you can't, like discrimination is kind of like the no-go for that. Like I guess like where's the line that can be drawn of what people can be fired for?
I don't know how to quite answer that, because I think that if you looked at the reasons for terminating somebody as a pie chart,
Mhm.
uh, the, the part of the pie chart that would be unlawful would be a little tiny slice.
Mm,
So almost anything could be, a reason for termination. It could be a personality issue. I've had several. I've had clients, and sometimes people get fired because they do something crazy at the Christmas office party. That seems to come up, now and then. So it really, again, it's just like I haven't really sat down and thought about all the crazy scenarios that I've had and reasons, but I'm always hearing something new in terms of why somebody may have been terminated. This is an area of law that deals with people, and people do all kinds of unpredictable things, and you can't you can't predict what people are going to do all the time. So there's a big variety there. I don't know how to quite answer that question, except to say that uh, again, if you look at the pie chart, there's the reasons that are unlawful are a little tiny slice.
okay, got it. So it doesn't happen as often as people may think it does.
Well, you know what? There's two parts to that. I would answer that in two parts. The stars have to align to have a claim, because you may have a claim where you are terminated for unlawful reasons,
Mhm.
but it's hard to prove.
Mm,
And the reason that it's hard to prove is twofold. One is that we're dealing with people's intent,
mhm.
and how do you prove intent in a discrimination case? I can go into the methodologies and all that. Well, the second part of it is that the law is also your case has to fit into the parameters of the law. So even if there is a violation of law that can possibly be proven, um, Florida happens to be in an area where the laws are interpreted in a way that are very conservative. We are in the 11th Circuit, which is Georgia, Alabama, Florida, and we have the most conservative circuit in the country in terms of employment laws, which is one reason why it's harder for people to find an employment lawyer in Florida than it is in California.
Mm,
It's night and day. I mean, we're geographically different,
mm,
opposite sides of the country, and in terms of the laws that apply to both, we're also opposites as well.
So when you say conservative, I'm assuming that it means it favors the employer more than the employee, or is it
I,
the
I,
other
I
side?
yeah, I think so, and that's a good question because these terms get thrown around so much,
Mm,
and I really think that my view, and I could go into case law, I think that shows this is that this circuit um, at times does not apply the law in the way that Congress intended for the law to apply.
mm,
And we see that because there are, justices on the Supreme Court, even Justice Kavanaugh, I think, who would be more in line with interpreting the law in a way that's consistent with the way Congress intended the law should be than 11th Circuit judges. So and again, an employment law is an interesting area of law because the courts are always tinkering with how to prove a case, and it starts with the Supreme Court. And it's amazing because they're still changing how they look at cases and how judges should look at cases. I mean, this has been going on basically since 1973, with the first case was McDonnell Douglas versus Green, and they've just been tinkering with it ever since and refining things. So it's in a state of, constant flux.
mm,
And when in the 11th Circuit, I think is more likely to interpret laws in a way that, in my view, are not consistent with Congress and can be more favorable to an employer. There's a recent case, I think it was the Tynes case, where one Justice Rosenbaum said, well, the majority has, thrown an anvil on the scales of justice in favor of defendants. And that's it's a pretty hot statement for a judge to make in an appellate opinion, but it was made. And I think that kind of illustrates how how tough the 11th Circuit could be with these cases.
mm. Okay. Okay. So then let's say, Gary, that someone is looking for help from a lawyer, but let's say they don't know any
Mhm.
lawyers, they're having trouble finding somebody. So what would be the most important piece of advice you can give to this person as they're doing their search so that they can find that lawyer that they feel has the experience, has the knowledge, and can really be, like, as you mentioned, their partner to get them through this situation? I mean, you see all these like cheesy lawyer videos out there, advertisements. So like, what
Yeah.
advice would you give to the average person so they can find a really good lawyer?
I think that you go on the internet and see who's got the experience. I think experience really does matter. The expression is you're practicing law, and that's correct. I mean, I guess you're in a constant state of practice. You never really, get it totally right, and you do learn things, and you learn what's going to resonate with the jury a little bit better as you go into your career. So I think that experience, and particularly in this area of law, you want somebody that knows employment law. You don't want somebody that dabbles in employment law. There are a lot of lawyers out there that might be personal injury attorneys or whatever, and they may be great lawyers. I don't begrudge that at all. But you really have to be in the thick of the law because it changes a lot more often than other areas of law. Personal injury law, based on my limited knowledge, it really doesn't change as much. Employment law is always changing, and there's always we have these little strange decisions that come out with the administrative process because the way the process is set up, you're supposed to file a charge of discrimination before you can go to court, et cetera, et cetera. And they come up every now and then, they'll come up with these opinions that are just really don't serve anybody because it creates a lot of uncertainty. So I think that's one of the main things that somebody should look for is, does this person really know employment law? I'm board certified in employment law by the state of Florida. There's 100,000, over 100,000 lawyers licensed in Florida. There are, last time I checked, about 169 that are board certified in employment law. Out of those, most of those are defense attorneys in Tampa. So it's a little tiny group that's actually board certified in employment law. And I think people also have to go with somebody that they're comfortable with. Um, I don't do, and you want somebody that's going to communicate with you. I think people should. Uh, I do better when there's an open line of communication. I give out my cell phone to people. I have friends that wouldn't dream of doing that because I want an open line of communication. I don't do a volume business. I don't want them to be afraid to talk to me.
Mhm.
I've learned that more is better. I want more information rather than less information. Now, typically in the initial interview, do I interrupt people a lot? Heck yeah, because I'm looking for certain things.
Mhm.
So at times I want to really get to the meat of it and get to, what the main points are. But I've also learned that everybody communicates in a different way. And I don't want to be in a position where I'm going to miss something, because somebody is afraid to call me or they can't communicate with me, things of that nature.
Okay. And you bring up another kind of really good point. Like when people are thinking through it, there is a difference between liking and get along with the lawyer you're working with and their ability to get you those results. So I guess if
Sure.
someone had to kind of like make that decision between do I get a lawyer that I really get along with and they have good ability, but maybe they're not the best one versus, hey, this is the best one, but I don't really like them. I don't really get along with them so well. Like, how would someone kind of decide which way to go with that?
Uh, that's I don't know. You got to find a happy medium, I guess.
Mm.
Um, yeah, I don't know. I think it's a mix of both, but I would say that you really got to start with experience, and that you get somebody that really knows what they're doing, and yeah, that knows employment law.
Okay. And you were mentioning like there's a lot of change like with personal injury law, like it doesn't really change too much, but with employment law, it seems like there's changing it, they're
Hmm.
tinkering on it. So are there any kind of changes that like kind of the average person should kind of pay attention to or be aware of with these changes? Or is it just kind of like more kind of minute that makes a difference in their case, but doesn't necessarily think to be aware of it?
I think the changes are there's a twofold question answer to that. One, the changes are mostly with how you prove a case,
Mm.
and the administrative changes. I don't think people have to be too concerned about that. For instance, with race discrimination cases, they used to say, well, you prove a case by showing that race was the motivating factor, so you could have other factors. Then they changed that to say, well, no, it has to be a but for test, that, but for the race, or something like that, that as a basis of discrimination, this person would not have been terminated, which is also the case with age cases. So that's sort of the minutia of how you prove a case. As far as, and the second part to that answer is, um, every now and then, it doesn't happen a whole lot, they'll add a new law or they'll add a new basis of discrimination. And I think that would probably be in the news.
Mm.
Sexual orientation discrimination. We didn't have that, I don't know, 10 years ago, whatever it was.
Mhm.
Some states had it. Now it's new. I think everybody knows that sexual orientation discrimination is against the law. We've seen it in the news and everything.
Mhm.
There's more trans issues coming up now, although I don't see that a lot in my own practice. But when there's a major change in the law in terms of the basis of discrimination, people are going to learn about that.
Okay, good to know. Now, Gary, throughout your experience and your career, I'm sure you've had some memorable cases or even challenging cases. Is there maybe one story that you're able to share of just one of those memorable or one of those challenging cases, and how you're able to get them a good result in the end?
I think that sometimes there's a bit of information that uh, comes up towards the end, or in the course of litigation, that I didn't know before, and that can make all the difference in the world. And looking back, sometimes that could be obvious. I had a sexual harassment case where they were denying vehemently that the person had, that she had been harassed, and then in the middle of mediation or something, she came up with a picture on her phone that clearly shows she was harassed. How
Mm.
she forgot that, I don't know. But she's like, oh, I have this, and then it just changed the whole thing, and it got, the case settled right away.
Mm.
um
The end.
yeah, I think great outcomes too are, Sometimes they come when somebody has the resolve to see a case through, and that could be a tough one. A lot of my cases settle, and I like going to trial. I wish I went to trial more, but there's lots of times when we just get a great offer, before during the course of litigation, and I never, counsel a client against settlement if I think I just want to go to trial to get more. If they really want to settle a case, I think that the best results come oftentimes on the eve of trial, and it takes a strong person to turn down what could be a significant amount of money and say, no, I'm going to hold out for this, and then press the whole thing towards trial.
Okay. And is there, I guess, for people who've never been through a situation like this before, like, is there kind of any, I guess I call it like a trick as far as like kind of deciding when should I settle and when should I go for it? Or is it really going to be case by case and how the lawyer you're working with advises?
Yep. It totally case by case, how the lawyer advises you. And that's a really, it's a difficult, question to answer, because this discovery is just that. You're discovering information, you're discovering new things and new wrinkles to the case that didn't come up before. And I think the person, has to really keep an open mind. I mean, that's really, the key to it is to and don't think your case is going to settle quickly, or that it's going to be, they're going to roll over right away and settle or anything of that nature. I've heard that a million times, and then we get into it and they don't do that. So it's really managing expectations, and on the employer side too, that there's sometimes there's things come up. There are surprises that or things that are going to be difficult to prove. They don't go our way, and you have to just adjust as you go along.
Okay. Well, great answer to that one. So now, Gary, I have one last question for you, but before I ask it, I do want to point people to your website at
youremploymentattorney.com.
Okay. Now, last question. What does peace of mind mean to you?
Peace of mind means that you don't think about this situation all the time. We've all had problems on jobs. My first job, I had a very difficult supervisor that fired everybody, and except me. I set the record, so I know how stressful it is. So I think peace of mind is a great thing when you can get some closure and put something behind you, and just not think about it. Not let it affect your family life, not let it affect your life going forward. Just to really resolve things and feel good about moving on.
Very well said. Well, there you have it. Gary sharing his expertise. So, Gary, where can people contact you in your practice?
Best place is my website, youremploymentattorney.com. It's singular. And the numbers are there. We answer the phone all the time, and happy to help.
Awesome. Well, Gary, this is great. Thank you for coming on, and thank you for sharing your expertise.
Thank you.
Thanks for listening to the Verdict Signal podcast. Any questions? Please contact the practice directly with the contact information provided during the show. We'll see you again next time. Bye for now.